Hello and welcome to episode 11 of Estate Planning Weekly. I am your host, Don Rolfe, and I am the owner and founder of Northwest Legal Planning, a Portland area estate planning and probate law firm. This week on episode 11, we are talking all about healthcare documents that would be included in your estate plan. So just to kind of set the landscape for us, there are generally three documents that we talk about when we're talking about healthcare documents. The first one is called a POLST. The second is called an Advance Directive here in Oregon. And the third is a healthcare power of attorney. And the last two are sort of interchangeable depending upon what jurisdiction you're in. Here in Oregon, we have a statutory Advance Directive, which I'll get to, and it's often supplemented with what we call a healthcare power of attorney. Now, the first document that I mentioned, a POLST, you may have heard about it. It's not something that everyone needs, and it's not something that you get as part of your estate plan, but it is something that a lot of people are familiar with. What it is actually a medical order, and it's for individuals who have advanced illnesses, they are close to death, those types of situations. And it's a form that you would fill out with your physician, with your doctor, and it's a medical order saying whether or not you would want heroic efforts to resuscitate you if you were to code. So if you have a heart attack, your heart stops, you stop breathing, whether or not you would want CPR performed, or whether or not you would want an electric shock performed in order to restart your heart. And that's a conversation that you have with your medical provider. And it's a document that, like I said, is not for every person. However, the second document on the list is one that everyone that is an adult should have, so that their wishes are known and that there is someone appointed who can direct medical professionals to follow your wishes, and that's an Advance Directive. Here in Oregon, we have a state statutory Advance Directive, which basically means that some committees have gotten together and made suggestions to the legislature, and they have passed laws to put together a form that is the same across the entire state, so that when physicians get it, they know exactly what they're looking at. The Oregon form has recently changed, starting on January 1 of 2019. The form was updated to a new form. However, if you have an old Advance Directive, it's still valid. You don't have to rush out and go get a new one. But just know that if you want to change your Advance Directive, your state statutory Advance Directive, the new one that you fill out from January 1, 2019 through until they change it again, it will look a little bit different. So this form basically sets up in four different scenarios: close to death, progressive illness, unconscious. In these four scenarios, whether or not you would want tube feeding or other artificial life support to keep you alive. And you can make different determinations on each of them, whether you do not, or you would, or you would want it if your physician recommends it, or you can just blanketly say you do not want it at all. You can also add additional instructions. So, if you have a particular set of circumstances where you would want it, you can include those instructions. And a particular set of circumstances where you absolutely would not want artificial life support or tube feeding, then you can add those instructions as well. It's not just a form. You can have your own personalized instructions and scenarios to set forth when and when you wouldn't want those things administered to you. This document also appoints a healthcare representative or healthcare agent, and usually you name a primary agent and a couple of contingent agents if the primary is unavailable. And these are the people who are being directed by your form, and you can in the form say whether or not you want that they have to follow your directions, or that they're guidelines, and And really this is a personal choice, and also how well the person that you're appointing knows you and whether you've had discussions with them about what kind of interventions you would like to get. The last form that I mentioned, a healthcare power of attorney, for my clients, I prepare this as an addendum to the Advance Directive. And this is a more comprehensive document that allows the agent or the healthcare representative that you've appointed to do more things. It gives them more powers. For instance, it could allow them to make sure that your pain medication is managed appropriately. Make sure that they can coordinate with hospice, gives them the power to do that. To seek psychiatric care for you if it's necessary. To seek in-home health care if your wish is to stay at home in your final days. So it's a more comprehensive document. It allows for more things rather than just the end-of-life instructions. So again, we have the POLST, which is a medical order that's filled out with your physician. The Advance Directive, which here in Oregon is a state statutory, and it's about making end-of-life decisions regarding feeding tube and other artificial life support. And then we have the healthcare power of attorney, or Advance Directive Addendum, as I call it. And that document allows for more comprehensive ability for the person that you've nominated as agent to act with regard to your health care if you are unable to do so, but not at the end of your life. I hope this answers some questions that you may have had. If you'd like to learn more, please listen to the other episodes if you're listening to it on audio, or head over to YouTube and check out the rest of the episodes. As I said, this is episode 11. If you like this, I'd appreciate it if you give it a thumbs up. Or if you have any questions, please put them down in the comments section. If you have a comment about this, I'd love to hear it. I would love to read those. And next week we'll be covering another topic. Until then, be well, and I'll talk to you then. Bye.